G'day everyone, this is Terry from Koala-Krafts again, and this is another WIP and Chat sort of kinda. You have some true crime coming through today. If I could get you to hit the subscribe button and also the bell so that you'll get notifications whenever I do a video. And also if you could hit the like button, that would be great. I'm trying to build my channel up as much as I can. This first one that I'm going to be talking about is the Derek Chauvin's appeal in the Floyd murder case. One of the issues with the appeal, did the district court abuse its wide discretion by denying Chauvin's motion to change venue, continue the trial and sequester the jury. As far as this appeal states, the court did not abuse its discretion, and for the following reasons. Chauvin argues that the district court abused its discretion by denying his motions to change venue, continue the trial and sequester the jury because 1, publicity and riots, both before and during the trial, combined with the city's announcement of a settlement with the Floyd family. As far as I'm concerned, these settlements shouldn't have been announced until after the trial was over. To me, this created a presumption of prejudice, and the jurors were actually prejudiced. But the court says, for the reasons we are not persuaded to grant relief. And don't forget, everything in here is my opinion. I've got most of this information from the interwebs, but I also have my own personal opinion, and that's what I'll be going to. Because these items are related, and the analysis ultimately depends on whether the district court ensured that Chauvin received a fair trial by an impartial jury. We addressed the issues together, as the parties have done. Generally, criminal trials must be held in the county where the offence was committed, unless the rules direct otherwise. A district court must grant a motion to change venue or continue the trial whenever potentially prejudiced material creates a reasonable likelihood that a fair trial cannot be had. Well, in my personal opinion, I think that's quite right. I mean, I think he was found guilty fairly and should have been found guilty, but there's still the prejudice of the jury I don't think I could get over. A party may move to sequester the jury either at the beginning of the trial or during the trial. I don't think that would have made any difference, because the way the news was flowing to and fro, even over here in as far away as Australia, it was all saying that he was guilty of doing it, or, more or less saying he was guilty. Similar to the requirements for a change of venue or a continuance. I don't think a change of venue would have made much difference, to be quite honest, because, again, as I said, we heard all about it over here in Australia, so I think you would have had to be living with your head in the sand if you hadn't heard anything about this trial. Sequestration must be ordered if the case is of such notoriety or the issues are of such a nature. In the absence of sequestering the jury, highly prejudicial matters are likely to come to the jurors. I don't know. I think maybe I don't think it would have made much difference, but it would have looked better, I think, if they were sequestered, if the jury was sequestered. This court will not reverse a district court's decision on whether to grant a change of venue absent a clear abuse of its wide discretion. Similarly, the question of whether to grant a continuance or a sequester, a jury is left to the discretion of the district court. Whether the district court abused its discretion depends on whether it properly assessed the likelihood that prejudicial publicity would affect the impartiality of the jurors and thereby prevent a fair trial. I think I would be able to, even if I heard a lot about it, I think I would be able to separate myself from what I've heard and what was from what I've heard from newspapers and television to what I hear in the courtroom. I was on a jury a few years ago now, and I went on the information that was shown to the court or explained in the courtroom. And because I felt that the police didn't prove their case, even though I thought the person was guilty, I had to find them not guilty, and so did the rest of the jury, because we didn't think the police did their jobs in bringing the evidence forward. So I think I would have been able to sit on a jury and make a decision from what's in the jury room, jury room and the courtroom. Prospective jurors cannot be presumed partial solely on the ground of exposure to pre-trial publicity. A fair trial does not mean jurors must be totally ignorant of the facts and issues involved. In an important criminal case that has generated public interest, and scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merits of the case. Well, that's true too. In relation to my case, I hadn't heard anything previously. But yeah, makes it difficult. The Supreme Court has aptly described this as prominence does not necessarily produce prejudice and juror impartiality. We have reiterated does not require ignorance. Under Minnesota case law, a criminal defendant seeking reversal on prejudicial publicity grounds generally must show actual juror prejudice. However, the Supreme Court has recognised that, in rare cases, publicity surrounding the trial may be so corrupting that it raises a presumption of juror prejudice. Regardless of whether an appellant bases their challenge on actual or presumed prejudice, the ultimate test remains whether prospective juror or jurors can set aside their impression or opinion and render an impartial verdict. Based on both Minnesota case law and the Supreme Court precedents, we hold that when a criminal defendant moves to change venue, continue a trial, or sequester the jury on grounds that publicity surrounding the trial created either actual or presumed juror prejudice. A district court does not abuse its discretion by denying the motion if it takes sufficient mitigating steps and verifies that the jurors can set aside their impression or opinions and deliver a fair, impartial verdict. Chauvin fails to show actual prejudiced by the jury. To establish actual prejudice resulting from publicity surrounding the trial, a defendant must show that the publicity influenced the specific jurors involved in the case. Factors appellate courts may consider include, among others, whether the publicity was factual, the length of time between the publicity and the trial, and whether the district court mitigated any potential prejudice at trial. Chauvin fails to show actual prejudice, first with a few very limited exceptions. The publicity was generally factual in nature. Chauvin claims that numerous news stories said Chauvin had his knee on Floyd's neck and Floyd could not breathe. However, the record, including the video, shows that Chauvin had one knee on Floyd's back and one knee on his neck. I don't see how that makes much difference. I think that sounds worse, in my opinion. Second, while Chauvin identifies the extent of publicity, he fails to analyse its content or explain why the publicity prejudiced him. Second, although the trial started in March 2021, approximately 10 months after Floyd's death, the district court found that the trial was very likely to generate substantial publicity regardless of when and where it was held. So moving the trial or delaying it would not have made a difference. This is consistent with the Minnesota Supreme Court's reasoning in Blom, BLOM, that nowhere in the state would Blom face a jury unexposed to the publicity about the case. And even if publicity may die down temporarily, it would reoccur once the trial started. Third, the district court took numerous steps to verify the seated jurors would be fair and impartial, thereby mitigating any potential prejudice. In Blom, the Supreme Court concluded that the district court did not abuse its discretion by denying motions to change venue, continue the trial, and sequester the jury, because it, among other actions, 1, continued to reevaluate the change of venue motions as new information arose and as new jurors were seated. 2, questioned jurors individually and extensively and permitted counsel to do so as well. 3, verified that all 15 jurors indicated that they would reach a verdict based solely on evidence presented in the court. 4, ensured that jurors who had been exposed to possibly prejudicial publicity agreed to follow the court's instructions. 5, instructed jurors not to discuss the case with anyone. Similarly, in Fairbanks, the Supreme Court held that actual prejudice did not occur when 1, a jury questionnaire was used, 2, the parties consulted in advance about which jurors should be excused before being summoned. 3, the district court granted each party additional preparatory challenges. 4, voir dire was conducted outside the presence of other jurors. 5, the court gave defence counsel ample opportunity to question prospective jurors about their exposure to prejudicial publicity. None of the 16 jurors selected indicated they had formed opinions about the case, and all said they would set aside anything they heard about the case. And 7, Fairbanks did not use all his challenges until alternatives were selected. As in Bloom and Fairbanks, the district court here took similar steps to ensure that Chauvin had a fair and impartial jury. The district court, 1, allowed Chauvin to renew his motions to change venue, continue the trial, and sequester the jury as new circumstances arose during the trial. 2, ordered an anonymous jury and conducted jury selection by sequestration, with each juror questioned individually. 3, required jurors to complete a comprehensive jury questionnaire with questions asking about their exposure to publicity surrounding the trial. Opinions about Chauvin and Floyd, participation in protests, attitudes about Black Lives Matter and Blue Lives Matter, and support for police reform. 4, directed jurors not to read or intentionally view anything about the trial or investigate or research the case, and promptly remove for cause any juror who did not follow this admonishment. 5, allow the parties to consult and stipulate to remove jurors for cause without summoning the jurors. 6, immediately remove for cause any prospective juror that had formed an opinion about Chauvin's guilt after the city announced a settlement with Floyd's family. And 7, increase the number of defence challenges to 18 and the state's challenges to 10. Moreover, as in Fairbanks, Chauvin did not use all his challenges and had 3 left. Unused challenges suggest that a defendant is satisfied that the jurors selected would be unbiased. Finally, and most importantly, despite the publicity, riots, and heightened security around the courthouse, all jurors who served confirmed that they could decide the case based on evidence presented in court and could be fair and impartial. The publicity surrounding Chauvin's trial was not so corrupting that it created a presumption of prejudice. So he didn't win any of them. He didn't win any of his appeals that he put in for. As an initial matter, Chauvin has not identified any Minnesota precedent in which an appellate court reversed a conviction based on a presumption of prejudice due to publicity surrounding the trial. Moreover, Supreme Court case law in which publicity resulted in presumed jury prejudice involved circumstances more extreme than those in Chauvin's trial. For example, in Rideau, R-I-D-E-A-U, the Supreme Court held that the failure to change venue violated Rideau's due process rights when his interview was broadcast on television multiple times, showing him in jail, flanked by his sheriff and two state troopers, and admitting details of the robbery and murder in response to leading questions. Also in Irvine, the Supreme Court held that publicity surrounding the trial raised a presumption of prejudice when one, newspaper accounts revealed the defendant's criminal history and juvenile record, that'd do it, his confession to the 6 murders, and he's offered to plead guilty. Oh, gee whiz. 8 out of the 12 seated jurors stated that they thought the defendant was guilty during voir dire, and in Shepherd, the Supreme Court held that a presumption of prejudice existed when 1, the media sensationalised the murder of Shepherd's pregnant wife and characterised his silence and refusal to take a lie detector test as evidence of his guilt. And 2, the trial was a media circus, with the press taking over the courtroom and sitting at a table inside the bar, less than 3 feet away from the jury box. Hampering defence counsel's ability to consult with Shepherd. 3, jurors were photographed when they entered or left the courtroom. 4, news articles falsely accused defence counsel of inappropriate conduct. 5, jurors were constantly exposed to news media, but the court did not admonish them to avoid such exposure. 6, the trial began 2 weeks before a hotly contested election in which the prosecutor and the judge were candidates for judgeship. And 7, the district court did nothing to control the carnival atmosphere. Unlike Rideau, Irwin and Shepherd, none of the publicity here included Chauvin confessing to the crimes. Further, the district court took numerous steps to prevent the trial from becoming utterly corrupted by press coverage, by sequestering jurors during trial, selection and deliberation, as well as controlling media to the trial by precluding video and audio coverage of pre-trial hearings. Its associated publicity was not so corrupting as to raise presumption of jury, particularly under either Minnesota or Supreme Court precedents. While there was substantial security around the courthouse during the trial, it was put into place to ensure a safe trial for the parties as well as the general public. As the district court pointed out, a smaller courthouse in a different venue would unlikely be able to accommodate the necessary security measures. We conclude that the district court took sufficient steps to mitigate the publicity surrounding the trial and verified that all seated jurors could set aside their impressions or opinions and deliver a fair and impartial verdict. It therefore did not abuse its wide discretion by denying Chauvin's motions to change venue, continue the trial, and sequester the jury based on actual or presumed prejudice. There was a few other appeals there, but they were nothing really, and none of them were given to him anyway. I have another pretty quick one. Just 1 second. Just have a quick break. What this one is about is Kathleen Folbig, and they're trying to get her a pardon or her charges squashed. And as I read through this, you'll know what the charges are about. So here we go. It's only fairly quick. For the first time in 2 decades, Australia's worst female serial killer could be pardoned for 4-time convicted baby killer Kathleen Folbig. The Department of Public Prosecution has accepted that new scientific evidence cast doubt on the mother's guilt, there are calls for the woman described as Australia's worst female serial killer to be released immediately. Kathleen Phobic's best friend and true believer says that the truth and the facts are finally in line. She says to hear it in the courtroom, she should have brought her tissue. She cried a river. Phobic has been referred to, as I stated before, as Australia's worst female serial killer, convicted over the deaths of her 4 children, Patrick, Laura, Sarah and Caleb, between 1989 and 1999. All appeals have been exhausted, and a 2019 inquiry upheld the guilty verdicts. But last year, a second probe was ordered following the discovery of a rare genetic mutation between Mrs. Phobic and her 2 daughters, and it led to this breakthrough. As to the 2 boys, Patrick, it could have been an epileptic seizure, but for the other boy, Caleb, there's still no reason for his death. Kathleen Phobic kept diaries which helped to convict her at trial in 2003. One entry read, "She left with a bit of help." Experts testified that these words were from a grieving mother, not a guilty one. The case for exoneration is growing. The Director of Public Prosecutions also accepts there is doubt, but Craig Phobic, the father of the children, cannot be convinced. The evidence is stacked in the 55-year-old's favour, and the prospect of a pardon is more possible than ever. Kathleen has asked for a bath, new pyjamas and a steak dinner on her first day out of custody. But there is still a lot of hurdles to cross before this could happen. Retired Supreme Court Justice, the retired Supreme Court Justice will consider the statements made today, and if he agrees and there is reasonable doubt, he may ask the Governor to consider granting a pardon. He could also ask the matter to go to the Court of Criminal Appeal in relation to quashing the convictions. In relation to this matter, I've never been sure one way or the other whether Phobic is guilty or not. I suppose she and the children are the only ones who will really ever know, and that answer will probably go with Catherine to her grave. So that's my opinion on that. I'm really not sure whether she had done it, whether she's done it or not. As I said, we'll probably never know for sure. I sort of hope that the children were sick. I mean, to me, either way, it's pretty bad. Anyway, thank you for listening. And again, subscribe to my channel, please, please, please. And click on the bell to get notifications of when I put up another video. I hope to see you again. As I said, thank you for listening. Keep safe, keep well, keep warm or cool, depending on which part of the world you're in. And I'll talk to you soon. Bye-bye for now.